सीपी लिस्ट को सेलेक्ट करें और फिर फ्रीक्वेंसी 110।
నమస్కారం. దూరదర్శన్ యాదగిరి ప్రాంతీయ వార్తా విభాగం సమర్పిస్తున్న భారతీయ నూతన నేర న్యాయ చట్టాలపై ప్రత్యేక చర్చా కార్యక్రమానికి స్వాగతం. భారతీయ న్యాయ వ్యవస్థలో కొత్త శకం ప్రారంభం కానుంది. బ్రిటిష్ కాలం నాటి చట్టాల స్థానంలో కేంద్ర ప్రభుత్వం తీసుకొచ్చిన 3 కొత్త నేర న్యాయ చట్టాలు భారతీయ న్యాయ సంహిత 2023, భారతీయ నాగరిక సురక్షా సంహిత 2023, భారతీయ సాక్ష్య అధినియం. ఈ 3 చట్టాలు జూలై 1 నుంచి అమల్లోకి రాబోతున్నాయి. ఈ 3 చట్టాలలో ఫోరెన్సిక్కు ప్రాధాన్యత కల్పించారు. 7 సంవత్సరాల పైబడి శిక్ష పడే అవకాశం ఉన్న కేసుల్లో ఫోరెన్సిక్ వినియోగాన్ని తప్పనిసరి చేశారు. ఫోరెన్సిక్ అంశంపై మరిన్ని వివరాలు మనకందించడానికి స్టూడియోలో ఉన్నారు సీనియర్ ఐపీఎస్ అధికారి, CDTI డైరెక్టర్ రాజశేఖర గారు. నమస్తే అండి.
నమస్కారం అండి.
భారతీయ నూతన న్యూ క్రిమినల్ లాస్లో ఫోరెన్సిక్ వినియోగానికి సంబంధించి ఎలాంటి అంశాలు పొందుపరిచారు?
In the new Bharatiya Nagarik Suraksha Sanhita, 7 years and above any crime, and if the investigating officer is proceeding to the scene of crime, it is compulsory to take the forensic experts to collect the evidence in those areas, because 7 years and above usually happens in heinous crimes, and the forensic evidence is very crucial in these kind of cases. Yes. And an expert is needed to collect. Maybe it is blood sample or an electronic record or a digital record, or for that matter any of the substance that is involved in the scene of crime, or this one. So the collection, packing, preserving, transporting and the chain of custody in fact plays a very crucial role. For example, in the electronic records and the digital records, the integrity of these evidences through hash value, and so that it is not compromised in between, is very important. So the collection is very crucial. We always say that the men may lie, but the circumstances may not lie. So some prosecution witness may lie, but the evidences may not lie. So this is the very crucial aspect, that 7 years and above any of the scene of crime or any offences, you take a team of forensic experts to collect the evidence that is all possible in that area.
What are the main provisions using forensic facility in new criminal laws?
Yes, in the new criminal laws there is a lot of facility for the forensic evidence. First of all, for example, in the Arjun Pandit versus Kailash Rao case, if we can take the section 65B certificate, whatever the electronic and digital records has to be submitted at the any stage of trial. But now you have to submit whenever you are submitting the exhibits into the court of law. Number 1. Number 2, in coming days, when the forensic from 1st July, if the search and seizure is going to be videographed, the witnesses are going to be present through video conference, even the experts can be produced through video conferencing. Even after the first time he is arrested, for the subsequent remands you can produce the accused via video conferencing. Even for framing of the charges, you need not to produce the accused, just secure the presence through video conferencing. There is e-summons and all those things. If you see sections 530 of the Bharatiya Nagarik Suraksha Sanhita, now everything has become audio, video or electronic and digital means in this one. Even when you make an arrest, when we recall the DK Basu versus State of Bengal, now that has been codified. Earlier it was said that a control room should be there. Now you have to have a designated officer of the rank of assistant sub inspector, and any arrest or seizure made that has to be produced even digital means. So the forensic value has been increased a lot. So in the coming days, where these forensic material, for example the digital evidence or the electronic records when produced to the court, where will be kept is one of the issues, because as of now the facilities in all over India is not so uniform. So the government has given a moratorium of 5 years so that you can use the forensic facilities either CFSL or SFSL, that is the Central Science Forensic Laboratories, or the State Forensic Laboratories to get the forensic expert opinion. So in these cases the 5 years is very important, because there are some states like Telangana, Karnataka, they have a very good forensic facility where a forensic team is already placed in one particular district, and it will be in strategic place so that it can help and nurture to the caters of all the police stations as and when necessary. But this is not the case even in northeastern states or some parts of in the mainland also. So 5 years moratorium is very good in this aspect, so that the forensic facilities are better equipped in all the labs, and also our people are well equipped and well trained on the forensic this one. We need more experts on the forensic experts to be involved in the investigation process.
ఎస్ జీరో ఎఫ్ఐఆర్ ఈఎఫ్ఐఆర్ డిజిటల్ ఛార్జ్ ఇటువంటివి కూడా ఈ సాంకేతికతను వినియోగించుకోవడానికి పెట్టారు.
Yes. Zero FIR, see, this is not a new thing. Actually, it was there earlier also.
Yes.
But only thing is that it was not given a statutory status, especially under 154 of the CRPC, that is the FIR. Now, 173 CRP is the new, 173 of the BNSS is the new section, which replaces 154 of the FIR. If you see 173, in the first sentence itself, it says irrespective of the area. That means to say that it is the zero FIR. Zero FIR in common term means, for example, when the complainant is traveling from one place to another, or he cannot give the complaint in the jurisdictional police station, he can give the complaint in any of the police station across India. The only thing is that receiving police station has to make an entry in the general diary and forward that complaint to the specific concerned police station jurisdiction. This is called as zero FIR. Now it is made legal and statutory. Second thing is the EFIR. So if you again see section 173(1)(2) of the Bharatiya Nagarik Suraksha Sanhita, it says even by electronic communication. That means to say that a person may dial 100, he can give a complaint, that is an electronic one.
Yes.
He can go to the website, he can file a complaint, or he can just make a telephonic call, or whatever it may be. These are all electronic communications now. Now electronic communication can be given to the particular police station or wherever he is. For example, he is in Punjab, but he has been frauded or criminal activity take place in Telangana. He can give it electronically even in Punjab also. So the EFIR will go to the particular police station or wherever it goes, and the signed copy of the EFIR has to be produced within 72 hours. Now the question is, before 72 hours whether the investigation cannot start. It is not like that. The FIR registration is just a formal procedure. Otherwise, as soon as the complaint has been received, whether it is signed or not signed, whether it is zero FIR, whether it is EFIR, whether it is unsigned or not signed, if a cognizable offence is made out, as stated in section 173, and as per the guidelines given by Supreme Court in the Lalita Kumari versus Uttar Pradesh case, when a cognizable offence has been made out, there should be a registration of the FIR. But if the cognizable offence made out or not, then there is a vague items, then they can go for a preliminary inquiry that has to be conducted in 14 days. Earlier in the Lalita Kumari judgment, it was 7 days. So this is about the EFIR and the zero FIR that has been mentioned in the 170th, that is the new law in BNSS. And also the fact that the filing of the charge sheet. See, charge sheet, the word charge sheet was earlier in section 173. Now it is under 193 of the Bharatiya Nagarik Suraksha Sanhita. Now charge sheet, because of the voluminous documents you might have seen in some high profile cases, there is a huge set of documents that has to be brought about to the court, number one. Number two, if there are too many accused or any like that, then you have to take as many sets as possible and you have to produce to the court, and the court in fact will give it to the accused or his accused counsel as the case may be. Now you can file it simply in a pen drive. In a pen drive, take that in a pen drive and give it to the court. You can file it online. Already the Supreme Court and the High Courts have already practiced using this technological means of filing the charge sheets or the final reports through the whatever the petitions in through e-filing. Now it has to come into the local police station or the local jurisdictional courts also, that where everything paperless and it will be dealt very easily and smoothly. So this is also using technological advancements that we are paperless and it is more speedy, because taking the copies, submitting it, although the law says 14 days time you have to give the copy to the accused, but I don't think much of the time will take just to take a pen drive as many as copies, or if for that matter you can send it by email also, or official communication also to the accused about the charge sheet submitted, and you can file online to the courts also. This will prevent lot of hassle free and loss of the papers, because we have seen in the courts that how much of papers have been present, how it has been destruction due to the course of the time. So I think it is a very good step from the logistical point of view, from the speedy justice point of view, and the safety and preservation of the material also.
ఎస్ విట్నెస్ అండ్ ఎక్స్పర్ట్స్, సాక్షులు నిపుణులు కూడా వర్చువల్గా కోర్టుకు అటెండ్ అవ్వచ్చు అనే అంశం కూడా
it is very important, because many of the times the complaints come and thereafter they don't appear. And another thing for the prosecution is that the prosecution witness come into for the court due to many factors. One is that they did not get the TADA and all those things. So this act makes very crucial that a person below 15 years of age, woman, physically handicapped, acute illness, person above 60 years of age, even is a prosecution, even is a witness, even during the course of the investigation, they need not to come to the police station. Although 41A notice has been issued by the police officer, he can always tell the police officer about whether he comes to belonging to these categories, and he can through via audio video means can give his statement, this one that is called as the witness. As far as experts is concerned, now it is under section 39 when compared to 45 of the Bharatiya Sakshi Adhiniyam. Bharatiya Sakshi Adhiniyam, it was said that foreign law, science and arts and experts in field. But now another field has been added, experts in any other field. So that means now under new section of Bharatiya Sakshi Adhiniyam section 39, now the experts need not to come to the court provided the document they produced, or the maker of the document, or the expert who has prepared that FSL report, forensic science lab report, need not to come to the court if the document is undisputed. Again, there is a timeline. 30 days, if any document is not disputed by either of the parties in the court, then it deemed to have been passed. So the experts also need not to come to the court to give their evidence. This also crucial, very important. Another thing, what happens in section 200 of the CRPC, section 223 of the Bharatiya Nagarik Suraksha Samhita, complaints to the magistrates. There the complaints have been given to the magistrates. There also, of course, it is stated that the substantial reasoning has been given to the even to the accused, where he is also given an opportunity to come to the court and give his explanation or whatever it may be. So these are all the things that has been made via audio video means. Another important thing, now the accused need not to be produced before the court whenever the charge sheet is submitted. Yes. Secondly, accused when he is asked for subsequent police remand, when the first police remand is asked, you produce him before the magistrate. But subsequent police remand, you need not to produce the accused before the court of law. Just secure his presence and say that he is well within the judicial custody or in the police custody, then you can take the statement or whatever it may be. That is all very important aspect that has been come, because it will prevent the travelling time, TADA, that expenses incurred by the witnesses and all those things. Because many of the witnesses does not come to the court because of many of the factors, including the expenses they involved and the daily routine they work of themselves. Right. This one, yes.
థ్యాంక్ యూ సార్. ఫోరెన్సిక్ వినియోగానికి సంబంధించి చాలా చక్కగా మంచి వివరాలు తెలియజేశారు. థ్యాంక్ యూ సో మచ్ సార్.
నమస్కారం.
కేంద్ర ప్రభుత్వం తీసుకొచ్చిన 3 కొత్త నేర న్యాయ చట్టాలు భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక్ సురక్షా సంహిత, భారతీయ సాక్ష్య అధినియం. ఈ 3 చట్టాలు జూలై 1వ తేదీ నుంచి అమల్లోకి రాబోతున్నాయి. ఈ 3 చట్టాలలో సాంకేతికతతో పాటు ఫోరెన్సిక్ వినియోగానికి ప్రాధాన్యతనిచ్చారు. 7 సంవత్సరాల పైబడిన కేసుల్లో ఫోరెన్సిక్ వినియోగాన్ని తప్పనిసరి చేశారు. ఫోరెన్సిక్ అంశంపై వివరాలు తెలుసుకున్నాం. భారతీయ నూతన నేర న్యాయ చట్టాల్లోని మరొక అంశంతో మళ్ళీ కలుద్దాం. నమస్కారం.